My name is Adam Mills. For those of you who don't know, I'm the president and CEO of the Kansas Restaurant and Hospitality Association. Over time, you find out that one of the challenges around the hospitality business is how to handle your largest asset, which is your labor. And between all the rules that you have to follow as a restaurateur, as a business owner, all the regulations you have to follow, and then, of course, keeping track of various changes in the law and changes in the marketplace, it can create a whole host of problems. So we thought it'd be a great idea to utilize Hinkle Law and their expertise, Eric Barth, today to tell us a little bit about what we might need to know should the Department of Labor ever come in your door. So with that, I'm going to turn it over to Eric, and then we'll have time for questions at the end. Thanks for being here. Appreciate it.
Thanks, Adam. Appreciate it. Can everybody hear me okay in the back? Okay. Like Adam said, today we're going to be talking about wage and hour investigations specifically. I know that some of you kind of are going through some of this right now. It seems the local wage and hour division and investigators are kind of targeting the restaurant and hospitality industry on a couple of issues that we'll kind of touch upon. And so what I thought would be helpful is to walk you through the process. You know, how does this happen? What do I do? What to expect? And what some options are, hopefully preventing some of these things from happening in the future if they do knock on your door. So again, my name is Eric Barth. I've been with the Hinkle Law Firm for about 16 years now. I do business and commercial litigation, and a large portion of that is employment litigation. So I do quite a bit of wage and hour, FLSA issues, as well as discrimination, different types of employment claims. So because we're a Hinkle Law Firm, we include this nice little disclaimer that this isn't intended for legal advice and that the law does change. So, you know, if you have a question in the future, please, you know, make sure that everything you're reviewing is up to date. So just briefly, what I want to talk about today is what the Wage and Hour and Department of Labor, Wage and Hour Division does. What laws are they going to look at? What do they oversee and enforce? So if they do come knocking on your door, you'll know what to expect and what they're looking for. The second thing I want to go through is kind of the process, what to expect each step of the way, what an investigation will look like, what documents you will need to provide, and how that will go about ending, and hopefully not too badly, and then you can go forward from there if there are any issues defined or identified. Next, I want to touch briefly on some issues that target your industry and that the wage and hour investigators are looking at right now in particular. And then, as I said, hopefully give you some tips on avoiding potentially some bad results. So today we're going to be focusing on the U.S. Department of Labor, the Wage and Hour Division. And there's different divisions within the Department of Labor, but the Wage and Hour Division focuses primarily on the Fair Labor Standards Act, which most of you know deals with minimum wage and overtime issues. They also are in charge of enforcing the FMLA, or Family Medical Leave Act, some other laws, Employee Polygraph Protection Act, the Consumer Credit Protection Act, as well as some labor standards that have to deal with the Immigration and Nationality Act as far as prevailing wage issues, as well as some issues with government contracts. That's mostly in the construction industry, so you don't need to worry about those. But that's kind of how the Wage and Hour Division, what they enforce. And so when they do come in and conduct an investigation, they're going to primarily be focused on the FLSA, minimum wage and overtime, and then some FMLA issues if your business is covered by that due to the number of employees that you have. It's not broadcasting, so bear with us.
A little song and dance real quick.
No, you don't want that.
Yeah, we do. We really do.
Eric, I have a question.
Yeah.
Are all these topics going to be anything related to state specific or federal is covered?
These are all going to be federal law, so it's going to be the same across the board. Now, that's primarily, I mean, that is what the U.S. Department of Labor will enforce. So there's going to be, and we'll talk about that at the end a little bit, but you're going to have some other state-specific issues and laws that they don't cover, and will lead to the individual jurisdictions where you might operate. So, but yeah, primarily this is just talking about federal law, which would apply across the board to wherever you are.
Good, we're good.
All right. So the Department of Labor, as part of its authority under the FLSA, has the authority to come in and conduct these types of wage and hour investigations, inspection actions. And they have the authority, if you don't comply with what they have found, they can possibly bring enforcement action against your company to make you comply with the law or pay back wages, those sorts of things. So by law, employers and companies that you own and represent are required to make this information available to the DOL. The DOL, if you don't, they do have the right to issue subpoenas to make you comply with either their request for documents or interviews of your employees or of yourself. And so kind of my first kind of caveat of dealing with them is to be cooperative. You know, most of the time there's no benefit in disrupting investigation, but you got to know, and hopefully we'll talk about some today, when to push back, when to fight back. But for the most part, it's best to deal with the investigators in a manner that's cooperative. They're not out there to put you out of business. They're not out there to hopefully not do too much harm to your business, but they are out there to make sure you comply with the law. Now there's gray areas of the law, there's changes in the law, and there's things that don't necessarily fit in the definitions of, you know, what should be compensated, what should be, for instance, in the tip pool situation, or there's some issues that aren't defined yet. And so those are going to be the issues that, if it's not clear cut, where you can push back or fight back. So, but throughout the process, it's best to be cooperative. And most of the investigators that you run into here in the Wichita office, they're easy to get along with. They're good people, and they're trying to do their jobs. We just got to make sure that they're doing it right, you're not overreaching, and that you are not put in a position where you're being made to pay for something that you're not obligated to, or, you know, if they're doing something, not calculating something right or something like that, or if you have good arguments that why the law shouldn't apply to you in a certain situation. But for the most part, being cooperative is the most important thing. So first off, an investigation, how does it start? And I will tell you that the first contact that you're going to get from the Department of Labor is either a phone call or an email or a letter from an investigator. And they will send you what's called an appointment letter, because they want to come in and set up what's called an opening conference with you. And I included in the PowerPoint what one of these looks like. This is a recent letter that one of the investigators here, his name is Lupe. He has been with the Department of Labor for about 4 or 5 years now. This is what the initial letter looks like. This is the type of information that they will request from you as far as providing records that they want to look at, and what types of topics they want to discuss at the initial appointment that they want to set up with you. So sometimes one of the first questions I get from clients is, why me? You know, was there a complaint? Was there, did one of my employees unhappy? And I will tell you, the Department of Labor investigators will not tell you. They will not tell you whether an employee made a complaint. They will not tell you who made it or anything like that. And some of that goes back to they don't want employers retaliating against their employees for making complaints. The other major way, though, I mean, complaints are one of the first and major ways that employers get these types of investigations. But the other type is an industry-targeted kind of initiative, I would say. And from what I've heard and what I've noticed in the last several months, the Wichita office is certainly going after the restaurant and hospitality industry. There's some specific issues dealing with minimum wage, overtime, tip credit, tip pooling issues that they are certainly going out and targeting restaurants. So I don't know that it's specifically driven by complaints, but more dealing with the industry as a whole at this point. So after you get the letter, the appointment letter, they want to set up what's called an opening conference, and they will show up and they will have their badge, they'll have their ID, they'll kind of explain what's going on. And what they're supposed to do is explain to you the intended scope of what they're looking at. They then will either deliver the first request for documents, or that's usually also included in that letter that I just showed you and attached that appointment letter. And like I mentioned before, the investigator does not need a subpoena to inspect these records and get that information. So that is kind of where you start. At the opening conference, then, the investigator is going to ask a ton of questions. And a lot of them are background questions dealing with your company. Who are the owners? Are there multiple restaurants, for instance? Are there multiple companies that own the restaurant? How does that all work? What's your your FEIN number? All of that. What's your volume of sales? And what those questions are driven to find out is whether or not the Department of Labor has jurisdiction and whether or not you're completely covered by the Fair Labor Standards Act. And, you know, is just one restaurant covered, or are they all covered? You know, how do those interplay? Those are what those questions are driven. They're also going to ask you how many employees you have. And again, those are driven to find out whether or not they have jurisdiction to investigate certain areas of your business. And for the number of employees, that has to do with FMLA coverage. And under the FMLA, the Family Medical Leave Act, you have to have 50 or more employees within a 75-mile radius. So if you're under that 50 employee threshold, the FMLA doesn't apply to you. If you have greater than that, they're going to be asking you questions to ensure that you are complying with providing the proper posters, that you are having, there's a poster that the Department of Labor puts out that should be included in your employee handbook on the FMLA, and whether or not, you know, that is visible to applicants when they come in to apply for a job. So if you have more than 50 employees, that's what the Department of Labor is going to start asking you further questions. Yeah.
Would that be per store or per company as a whole?
If it's 50 employees within a 75-mile radius. So if you have one store that's got 25 and another store that's got 25, and you're within a 75-mile radius, that would be covered.
Even if they're incorporated differently?
Yeah, and that starts to get a little bit further, more specific, but yeah, typically they'll say, are they common ownership and all of those types of issues. But if you have a store here that's got 25 and you've got a store in Kansas City that has 25, you're not going to be covered under the FMLA. Other employees, you run into situations where you might have 50 employees here. Our law firm has this situation. We have more than 50 employees here, but in our Overland Park office, we don't have that many there. And so technically under the law, those employees aren't covered by the FMLA, but the ones in Wichita would be. So the next thing, the investigator is going to ask you all kinds of questions about what types of employees you have, what categories they are, and that's going to deal with job titles and job duties, but it's also going to deal with, so, you know, do you have servers, do you have busboys, do you have hostess, do you have line cooks, all those types of questions. But then they're also going to ask you questions about managers. Do you have managers, shift leaders, you know, those types of questions, and whether they're paid hourly or on a salary basis, so that they can start to get information that'll be helpful to them to start going through the records. Yeah.
Back to his question about the 50 employees.
Yes.
For purposes of the FMLA, how do they count employees? And what about a part-time employee versus a full-time employee? Is it a half employee?
I have to, off the top of my head, I think part-times are counted, but I have to, I can confirm that for you.
Thank you.
Because that does happen. You know, you start running into that. Okay, I've got 49 and a half, or I've got, you know, I'm not sure if we're covered or not, but I can confirm that real quick for you. The investigator is also going to ask you about your timekeeping procedures. Do you use a time clock? Do employees clock in and out using, you know, a time clock? Do they use time sheets? Do they use some kind of software on a cash register or on a computer? What do they use? How is the hours, are they recording? You know, do they record minute by minute, or the FLSA allows rounding to be done? So they want to know that you can round to the nearest quarter hour. So if you work, you know, 1 to 7 minutes, you can round down, but if an employee works 8 to 14, you have to pay them a full quarter hour. So they just want to make sure you're doing that right, if that's in fact what you do. I don't see that too much anymore, given some of the computer software, and you'll see a lot, and I don't know how all of yours are, but you'll see 10.62 hours, you know, you'll see that kind of detail in determining how many hours are worked. You're also going to be asked about your payroll practices. How often do you pay? Do you pay bi-weekly? When does your work week begin and end? Is it Monday through Sunday? Is it some other arrangement? How does that work? So that when the investigator starts going through those payroll and time records that they've requested, they understand what they're looking at. The investigator will also ask you about minors, and do you employ anyone under 18? Okay, do you employ anyone under 16? Because if you do, you'll know if you employ 14 or 15-year-olds in the restaurant industry, there are certain job duties they can and can't perform, and there are certain time limitations put on when they can work, how many hours in a work week they can work, depending on whether school is in session or not. So those are all the types of things they're going to be looking at. And they're also going to want to do an on-site investigation as part of this. And this can be done with your consent, or they can go and get a subpoena again. But one of the important things to remember here is they have to do it in a reasonable time, at a reasonable time, within reasonable limits. So they cannot, and they're supposed not to, interfere with your normal business operations. And for, you know, specifically for your industry, you know, one of those things is, hey, don't show up at lunch hour. You know, we're busy. Don't show up during the dinner rush. We're trying to wait on customers. We're trying to get things done. So let's try to do it at a different time. And that's one of those things, like I talked about, you want to be cooperative, but at the same time, you want to run your business. You want to serve your customers. So during the on-site investigation, they may take a look at what your employees are doing. You know, what are their job duties? Some of those is, you dishwasher, what are they doing? What's the server doing? Those types of things. They may hand out business cards to your employees. We'll talk about this a little bit, but as part of this process, they're also going to be talking to your employees. So they may try to have a short, stop and talk with an employee to say, hey, what are you doing? Or, those types of things. Again, I think you are best served if you escort the investigator, walk them around. If they try to do more than just a brief interaction with an employee, and it's during a particular time, I think you need to say, hey, can we reschedule this? Let's do this at a different time. The investigator is also going to look and make sure you have all the updated posters that you're supposed to have. And so whenever I get a client that says, hey, I got one of these letters, the DOL investigator's coming out, excuse me, one of the first things I tell them is make sure you have all your posters up. Make sure you got them in the right places, make sure the employees can see them, that sort of thing, because that's what they're going to be looking for. Yeah.
Regarding the interview with the employees, when he interviewed mine, he actually sat down with them in the room away from everybody and sat down with them for anywhere from 5 to 15 minutes each.
Yeah, and I'm, no, you're fine. I was just going to get to that. I was going to say the interviews of your hourly employees are typically going to be private.
Sorry.
No, you're fine. This is perfect. And they want to take them away from their job so they're not interfering with your business typically, Now I've heard horror stories and seen firsthand, not in this area, but up in Kansas City, where you've got investigators coming onto clients' property or customers' property, kind of interfering with, hey, we're doing something here, let's do this at a different time. Most of them are going to be short, 5, 15 minute long, but they're going to be, if they're hourly employees, they're going to be done in private, and unfortunately, the employer cannot be there. And if you have an attorney involved, or they're not going to be able to be there either, because supposedly it's about, you don't want to intimidate the employee or anything like that. So part of the purpose of this is to get from the employee's perspective, is everything matching up with what the employer's telling you? You're saying, okay, you work typically 40 hours a week. This is what your time records show. Is that true? And want to make sure there's no off the clock issues. Is somebody alleging that they are working more than what is being recorded, or they're not being paid for that? They're going to, and maybe some of them, they'll ask, what their job duties are, or different things like that. Now, if the DOL does want to talk to a manager, a management employee, the employer has the right to have a representative there, or an attorney can be present, because they are seen more to be able to bind the company as far as what they say, how they do things. So you want to, if they do want to talk to one of your managers, you do want to take advantage of the opportunity to be present, or have counsel present, or a representative present, so that you can know what's being asked, you can clarify any misunderstandings, that sort of thing. So during these interviews, the investigator is going to take notes. They're going to ask questions about the documents that they've either already looked at or intend to look at, and they can, in some instances, and will ask them to sign a statement if on a particular issue. If they're, for instance, talking about off the clock time, they may ask you to, or may ask the employee rather, to sign a statement along those lines. They, will also ask the employees, how, maybe different questions about how the employer's practices are. For instance, how do you guys tip pool? If you tip pool, do you make enough to satisfy the minimum wage? All those types of questions. Do they deduct anything from your paycheck? Do they deduct for uniforms or things like that. So, they are attempting to get background information both from you and your employees so that they can look at the records and determine whether or not you're complying with the FLSA. So with respect to interviews, most times they're going to try to schedule those in advance. And like I said before, if they try to schedule your interviews with your employees that interfere with your business operations, that's when you need to push back for sure. You can do it professionally, do it courteously, but you need to do it so it doesn't interfere with your normal business operations. Say, hey, you know what, we're short-staffed during that time. That's a bad time for us. Can we do it a different time later on at the end of the shift, that kind of thing. And request it in a location. And I think most of them try to do this, do it in a private room where it's not in front of everybody, so that it's out of the way. The other thing that I will emphasize, and that they will tell you, the investigator will tell you, but I will tell you even more strongly, is don't retaliate against an employee that's been interviewed or that's made a complaint or that's talked to the DOL. That is going to get you in more trouble than if you had just, forgot to pay him overtime for an hour, or you didn't calculate something right. Okay, we can fix that. We can figure that out. But if you start retaliating against an employee by, cutting their hours, firing them, anything like that, that's going to get you in way more trouble. So definitely don't retaliate if somebody is cooperating in an investigation. After they talk to your employees, they're going to start going through the records. And they can do this a couple of ways. You can insist that they stay at your establishment or your accountant's office or your lawyer's office and look at everything right there. Or they can take them with them, or you can deliver them electronically. Most of the time, it's going to take a long time to go through them. So if you don't have any, sounds bad, you don't have anything to hide, so to speak, there's no point in just letting them just sit there all day. Give it to them, let them go, digest it. But with that, expect more questions. It's always going to happen. And they might request more documents. You're going to go through it. For instance, I'll give you just an example. You start going through it and you say, okay, you employ this minor and she's 15, and there's some certain rules about school weeks and when they can work and how much and all those kinds of regulations. I see here that they were working more than 18 hours in a week, which is allowed in a school week if school is in session. So the investigator might ask you, okay, well, where does this person go to school? And then they will go and kind of look at the school calendar, perhaps. If you have a location, say, in Derby, they're going to go to the Derby school website and they're going to say, okay, well, during that week, that was spring break and they were completely off of school. And so, they're okay to work up to 40 hours a week. Expect those types of questions, but you might get others, how did this person, when did they quit? When did they turn 16? All those types of things that might come up as the investigator goes through the records. And so you're going to get more questions for sure. And so what you want to be able to do is respond in a way that doesn't, answers their question directly, but you want to be smart so that you don't open a can of worms to other things. And that's something we can talk about too. Yeah.
So backing up to the private interview that they may have with an employee.
Yeah.
Let's say that it is a minor, or there are some violations that maybe the minor doesn't care about. maybe they aren't alarmed by the misuse or the misrepresentation or the accident made by the employer. Will the department still pursue that issue? And to what extent will they pursue that issue? And will they ever recommend, for instance, someone going and taking action? Is that part of what they do, or are they just gathering information?
When you say take action, do you mean they
Like if
pursue
you're
it?
violating child labor law, are they going to tell that individual, or maybe inform the parents or whatever, hey, take this to your parents, you are not in compliance, you need to find counsel to take action against your employer?
No, what they're gonna do is they're gonna say, you screwed up and we're gonna take care of finding you
Okay.
and those types of things. Because that's how they see their role as more of the enforcement. So if you're not being paid overtime, if an employee isn't being paid overtime, the DOL is gonna recommend, you screwed up, you need to pay this person overtime. And this is how much we've determined. And so they typically don't suggest, hey, you've got this great lawsuit, go hire a lawyer. Instead, what they're going to say is, you screwed up and we're going to make you pay, type of a thing. So, but and to go back to the private interviews, for instance, a good question though for, say, for a minor employee. Minors cannot work, if you're 14 or 15, you can't work after 7 p.m. if it's between Labor Day and June 1st, basically when school is, right? So what if you start looking at, if the investigator starts looking at the time records and they see, hey, this kid clocked out at 7:03. Okay, to the naked eye, that looks like a technical violation. You know, that's a violation. They're not supposed to work past 7. Well, and I've had this discussion with Susan Lang, one of the investigators here, and one of the areas that they could flesh out in a private interview with that employee is, okay, were you really working past 7? Or did you stop working at 6:55 or 7, and it just took you that long to clock out? And the investigator's going to ask those types of questions. And they're going to look at your other time records. Do most of the times does it clock out at 6:55 or 6:58? And you have a few, 7:03, 7:10s, those don't necessarily indicate a willful violation by the employer, And unfortunately, there are good faith defenses to, and we'll talk about this a little bit, to what they call liquidated damages, but there's not always a good faith defenses to, hey, I meant to comply with the law, but I didn't pay them overtime. That's not really going to fly. It's not really going to get you out of some of these violations, unfortunately. So after and I will say this also, when I say expect more questions, that may trickle in, or it may be kind of all at once. Here's 15 things I have questions about. And the investigators will say, I need this within 2 to 3 weeks. And that's when you say, hey, I'm running a business here. I'll try to get you this stuff as I can, but, I may need more time, those sorts of things. The next kind of step is what's called it's called the closing conference. And that is what is done after the investigator has gone through all the records, has talked to the employees, has asked you as the employer any additional questions. They will sit down with you particularly if they find issues and find violations. They will sit down with you in what's called a closing conference and provide you and communicate with you what they have done. And not only that, but kind of the reasoning behind what they have found. So to give you an easy example that you all know, you're supposed to pay an hourly employee overtime if they work more than 40 hours in a work week. So if they go through the records and they find instances for whatever reason that it wasn't done, whether it could be a software glitch, it could be it just wasn't done. Maybe you switch softwares, you know, whatever reason. They will sit down and they say, you should have paid this employee 2 hours of overtime when they worked 42 hours this particular work week, and therefore, you know, we've got a violation here. And they'll explain to you the reasons why. They will also explain to you what actions you're going to need to do in the future. Yeah.
In my situation with my initial conference, we discovered that yes, you're supposed to, because we're the restaurant industry, if the tip wage, the overtime isn't based on their tip wage, it's actually based on minimum wage at 1.5%. And it didn't apply to very many of my staff, but there were a couple of servers that were paid at their tip wage.
Rather than the $7.25.
Right.
Yeah. And you see that, and that's just an innocent mistake.
Absolutely.
You know, but unfortunately they don't care about that at that time. They're just going to say you should have done this and you need to comply. I've had instances, not with restaurant clients, but just an example of how stuff can just get screwy. I had not a client, but it was an example when we were going through one of these that the investigator used, that the company was taking whatever hours worked for the 2-week pay period, sending that over to their accountant. They were looking at it and they were saying, okay, if it's basically more than 80, we're going to pay you overtime for whatever hours in that 2-week period. But that's not what the law says. The law says it's over 40 in a work week, you get overtime. So you can have instances in this example that the investigator is using, where you have 42 hours in one and 38 in another. Those add up to 80, so it doesn't look like there's a violation, but in fact, there is a violation. And so you're going to end up owing overtime. And so you brought up that, you know, they're going to tell you, okay, in the future, what do you need to do? Well, you need to figure out overtime based on minimum wage, not your tip wage or your tip credit wage. And so how are you going to do that? Are you going to, and then you can kind of go through, well, we're going to look at that closely, or we're going to ask our accountant, we're going to figure out software, whatever it is, so that in the future, we can comply. Sometimes it's as simple as just letting the investigator know, hey, we screwed up, we're going to pay overtime in the future for hours over 40 worked. And this is important because if they identify issues, and I'll talk about this a little bit more as far as what's called willful violations. If they come back to you in another couple of years, they come back to you in 2 years and say, you're doing the same exact thing you got in trouble for 2 years ago, now we're going to assess you penalties. You know, right now we're just going to make you pay whatever that amount is to your employees. Maybe you have to pay some liquidated damages, but we're not going to make you do penalties. We come back in 2 years and you're doing the same thing, you know better now, and we're gonna fine you in addition to making you pay that. The Department of Labor is going to assess you some penalties. Also, they're going to explain what rights you have, and we'll talk about this more, kind of what's next, so to speak. And they'll explain to you what you can expect if you are going to go ahead, and if it's a small amount, it's not worth fighting, you know, go ahead and pay it. How do you do that? And we'll talk about that here in a minute. Or is it a more significant issue that, hey, this isn't really clear cut in the law, I don't think this should apply to me, or I don't think it should apply this way, you know, what remedies or what options do we have if the investigator finds some violations here? So just briefly, with respect to what remedies are available, what can you expect? So the main thing that the investigator is going to focus on are what's called back wages and liquidated damages. And back wages under the FLSA, you typically look at a 2-year look back period, because that's what, under the law, that's what your statute of limitations is. So you typically will look at 2-year periods. Now, they will at times ask you for 3 years of certain records, and if it is deemed that you were willful, for instance, if they come back later and find that you're doing the same thing, then they're going to look at an additional year and possibly make you pay back wages for that. In addition to those back wages, they will likely assess you what's called liquidated damages, which is an equal amount of the back wages that are due. Now, there are certain defenses, what's called good faith defenses, to those liquidated damages, but I know that the investigators will typically take the approach that in order to establish a good faith defense, you have to show that, hey, I relied on the advice of my attorney, or I relied on the advice of my accountant, or you know what, I relied on this DOL guidance, and this is why I'm doing it this way. Otherwise, and that's kind of a hard hurdle sometimes to overcome. And so typically they will say that liquidated damages, in addition to any back wages that you're going to have to pay, are also due. And those also go to the employee. So if you, during the closing conference, if they say, okay, you should have paid Bob $20 in overtime, well, you're going to have to pay him $20 in liquidated damages, so Bob is going to get $40 in total compensation because of these violations. The other thing that the other remedies available to the DOL are, excuse me, are penalties. And what Adam was talking about just a little bit ago, you have child labor law. If you have a child labor violation, there's no back wages due. You're not going to pay assuming you pay the minor employee everything that they should have been paid. If they work past 7 or they worked more than 18 hours in a school week, what the DOL is going to want to do is assess you a penalty. And the investigator is not going to be that person that assesses the penalty. That's figured out by someone else in the department, kind of above them. And what the DOL will tell you are, unless it's going to be egregious, and they're not going to fine you that much on like child labor violations. But where you get into penalties that are going to be bad is what we talked about, the repeated violations. They come back and they say, you should have corrected and you didn't, you willfully disregarded the law. We're going to charge you, or assess you rather, penalties up to $1,000 for each violation. And there's also some criminal penalties involved, but that's very, very rare. So during that closing conference, they maybe tell you some areas that you're not fully in compliance with. It happens. Everyone, don't feel bad. What can we do to fix it? But there are going to be some areas where you're like, hey, I don't think that's fair. That's not spelled out in the law. And we'll talk about a couple of those issues. What are my options, basically? So what's next? What can I do? And first thing I say is kind of, pay up, pay or fight, so to speak. The first thing you can do is, and a lot of this depends on the amounts involved. If, you go through all this and they look at 2 years worth of payroll records and they say you owe employees, $500. Well, it might not be worth fighting. And if it's clear cut that you screwed up, even though you didn't mean to, it may just be worth paying that amount, fixing the issue, and going on down the road. And we'll get to how you do that and the benefits of doing that. But if the investigator's findings are based on something maybe that's incorrect, maybe they didn't completely understand a practice or a procedure for how you, maybe how you did your tip pool or something like that, this is a good time to say, hey, can we provide some additional information to you? Can we provide some additional records to you to clear up and to clarify those misunderstandings? With respect to paying, they will provide you, the investigator, if you determine that that's the route you want to go, they provide you with a summary sheet of what's due. They call it a summary of unpaid wages. And like I said before, that's where they'll list out, this is the overtime due, or this is the, liquidated damages. The employee should receive this amount. And what's important here is the next step. If you do decide to pay, they provide you a form called receipt for payment of back wages. And why that's important is because it contains a release of liability. So if the employee accepts the back wages and they sign that they've received it, there's a statement on there that says they waive their right to later bring a claim. Go to an attorney and say, hey, I want to sue. I have this wage claim. If you've already had the employee sign the DOL authorized settlement and receipt of back wages, they cannot do that. And that's important because FLSA and back wage claims, you can only successfully, completely, fully release those types of claims in two ways. One is through supervised DOL payment, and the other is through court approval. If you go through a lawsuit that seeks back wages, you can get a court to approve a settlement. There's ways to get around that and try to mitigate that. That's kind of a topic for a different day. But if you pay back wages through the DOL supervised payment like this, that employee is going to waive and completely give up their right to go file a lawsuit later. So you do have that peace of mind that is going to be a successful release. The next thing, if the amount is higher than what you think, what you can pay, all those things, that's when you can try to negotiate kind of an informal settlement with the investigator. And specifically if there's some issues involved, and if there's some gray areas, if you think, I'll talk briefly about it in a minute, there's some new tip pooling rules in the last year, and one of those, the Congress kind of clarified that managers or supervisors shouldn't be included in the tip pool, regardless of whether or not the employee or the employer took a tip credit. So before March of 2018, there were some instances in which employers had tip pools and included maybe managers or supervisors if everyone was paid above the minimum wage, $7.25 or more. But now that's kind of changed. Now there's some questions about what I will kind of refer to as designated versus undesignated tips. You have situations where restaurants, and you all know this, and you don't always have a sit down and a server who serves you your meal. Sometimes you have an open kitchen concept, you go through a line, you're served by 4 different people, well, who gets the tip in that situation? Those are the types of issues that could be gray areas where you can push back to the investigator and say, hey, look, we're not your typical service restaurant. We do things differently. And this is kind of a gray area that the law hasn't caught up with yet. And so you can attempt to resolve some of those issues of fact and try to negotiate a settlement. The next kind of level is to fight it more and attempt to negotiate what's called a formal settlement with the DOL attorneys. That kind of takes away the investigator, gets them out of the picture, and you go to the next step. And the final step is to go to court and fight it out, which is expensive, it's time consuming, it's not what you want to do in most cases. But again, it's usually a cost benefit analysis. You know, what amounts are we talking about? Are we talking about small amounts? Is it better and easier to pay to change a practice and move forward? Or is it something more significant? Is it a tip pooling issue that maybe isn't clear cut and involves a lot of money? Maybe it's how you're classifying a particular employee as exempt or non-exempt that could result in that person being considered not exempt from overtime, and you're going to have to pay that person or a category of employees overtime, and that's going to be a lot of money. Those are the things where it might be beneficial to fight and try to come up with a more of a formal settlement, if you will. Now, if you do get, proceed to court, you're going to be in the press, expect a press release, expect to receive some backlash publicly. DOL and all the federal agencies love to issue their press releases. We sued Wendy's for this, or we sued, Walmart for that. I mean, they love to have those types of headlines. But that's kind of the next step after the closing conference. And so briefly, you all can, probably better than I can, say, what are some of these investigators looking at right now? And, definitely minimum wage, making sure that if you have any deductions, that you're not dipping an employee below the minimum wage, how that works. And then another always big one is overtime. Are you properly classifying an employee, for instance, a manager or an assistant manager? You see instances where an assistant manager may be more akin to an hourly employee, and they're being classified wrong based on their job duties, or whatever the case may be, where the investigator, the DOL, finds, hey, they're not exempt, and you should have been paying them overtime. You've kind of labeled them or categorized them incorrectly, so we're gonna have to look at that. And along with that, the new overtime rule, probably most of you are aware, takes effect on January 1st of next year, 2020. This raises the salary level, and this is going to affect your managers. Yeah.
Is actually kind of a question directly to this. You had lumped or referenced managers and supervisors together in previous statements about who may or may not be eligible for tip pooling.
Yeah.
And this is something I need to look into further on my own stuff. But how, in the new regulations, what distinctions are made between supervisors and managers, and who doesn't? How do they not qualify for the tip pool?
First, can you state what the change is? If you started to say what it's.
Oh, man, okay. Yes, and then I'll come back to your question. Starting January 1st. So right now, the current salary level is $455 a week. So that's roughly $23,660. So starting January 1st, the salary level goes up to $684 a week. $684 a week. So that's equivalent to $35,568 per year for a full year worker. So that is going to take place on January 1st. As most of you know and will recall, the Obama administration in 2016 was going to raise that twice as much and face a lot of backlash. There's some lawsuits in federal court, one in particular down in Texas, in which the court blocked that rule from going into effect. And so at the end of the Obama administration, it kind of went away. Trump came into office and the new DOL started looking at that and kind of scaled back those salary levels. Like I said, the Obama DOL, with the salary level was going to be raised to $47,476. So quite a jump from, and so you were going to, I'm sure all of you kind of face this in other employers as well. I have a manager who's making $40,000 a year. Am I going to raise them, you know, $7,476, or am I going to pay them overtime? You know, how much overtime do they work? What's feasible? So you had to go into a lot of these kind of analysis as far as what, whether you were going to comply with that or make them kind of an hourly employee. So this is roughly, it's 12,000 more a year. So, I mean, you're going to have to do similar if you pay your manager somewhere between, you know, what the current $23,660 and the $35,568, you're going to have to kind of do that same analysis in order to determine whether you're going to keep that employee, that manager, or that exempt employee exempt from overtime.
Eric, bonuses were a big thing with mine, and how if you have an organized, structured bonus or incentive program versus having a random incentive. And honestly, he said having a random works in our favor.
So the new law, which is very much like what the 2016 or new regulation, allows employers to use what they call non-discretionary bonuses, including commissions that are paid at least annually, to add up to 10% of that salary level, that $43,660. That takes effect January 1st.
That's something I think completely different. But ours didn't have to do with whether it was salary
Yeah.
or hourly. It was, you get a X% bonus if you hit X in sales. If you do that, that bonus has to be calculated into their overtime wage. They're very big right now into your blended overtime rate. I sent you an example of one of my employees.
Yeah, you look at your regular rate, you know, overtime is based on, you know, 1.5 times your regular rate. Well, you're going to have instances where a person has 2 types of jobs.
He has 2 roles, and the second role, he went into overtime the second week of the pay period he only had 1 shift in the second role, and that was at a higher wage per hour. And he ended up getting 3 hours of overtime. And the blended rate, according to my Square POS system, my timekeeping is held, offered a blended rate with a warning. And when he clicked the warning, it said, oh no, we're just guessing. Like, these laws are way too complicated. You absolutely have to check with, you know, your state, not my state, it's not the state.
No, I mean,
federal level.
Yeah, I mean, and so with the blended rate is, like you said, taking those 2 and averaging, but it's a weighted average versus how many hours you're working in that role versus the other role.
Right.
So it can get complicated quick. The other question was, what are they going to look at to determine whether somebody's a manager? And
So they were very specific in our interviews.
yeah, there's a regulation that talks about, and
Kurt.
Yeah.
you actually brought it with you, I
Yeah.
think. And it talks about what are the executive level, you know, do you supervise 2 or more employees? That's that executive employee regulation is what the DOL is going to look at to determine whether somebody is a manager and whether somebody is allowed a supervisor or a manager for the purposes of that tip pooling rule. So that's where they're going to be looking. And so last year in March of 18, like I said, there was Congress enacted an appropriations bill that snuck in some, I say snuck in, it wasn't It was an appropriations bill where they had some changes to this regulation dealing with tip credit and tip pooling. And like I said before, if you weren't taking a tip credit, you're paying your employees at least $7.25, the minimum wage. The DOL wasn't concerned with who was all included in the tip pool. You could include your dishwashers. You could include, because the tip pool traditionally, and under the regs, is made up of those occupations that customarily receive tips. And so now it's changed to say it doesn't matter. On some of these, for instance, the law has changed the wording. If you cannot include a manager or a supervisor in a tip pool, no matter if you take a tip credit or not. And that's a new distinction that occurred in last year. And like we talked about, one of the issues with this in the Department of Labor, the law, the section says you cannot take an employee's tips and distribute an employee's tips. Well, what's that mean? And in some of your instances, that's not the employee's tips. You know, that's what some commentators, they call an undesignated tip. And I'll use a Chipotle example. You go through the line, you have 3 or 4 people making your food. You have a cashier that's ringing your food up. Okay, you put some money in the tip jar, or maybe you add a small tip to the credit card receipt. Well, that's not a particular employee's tip. Sometimes a customer is tipping because of their overall good experience that they've had at your restaurant. They want to tip everybody. And you get in these situations where you have managers or supervisors who are working side by side with the hourly employees. They're making the food. They may be ringing the person up. Well, you gave the tip to that cashier, but you know, they had no more or less to do with the service than another employee. So that is one of the gray areas, and that's where DOL is coming after several businesses I know on those issues, those tip pooling issues and tip credit issues, because I don't quite think that the law and the DOL regs have caught up to modern times. You know, we're not talking about a traditional sit-down service restaurant where that tip belonged to that employee, and then you're tip pooling because maybe another server had a bad night. That's, you know, that's fine. That's a traditional model, but then you wouldn't include dishwashers or bussers in that. But, you know, times have changed, and there are different concepts. The open kitchen concept where, you know, everybody is involved, including managers. DOL here is taking the position that change in the law means that managers should not be included in your tip. Whether or not you take a tip credit, you can pay all of your employees $7.25 or more, and they're going to tell you your manager shouldn't be included in those tip pools. Now, depending on your circumstances, that's going to be a situation where you might want to fight it because it's not clear, and it could be a situation where you're talking about a lot of money, and so that's going to be where you might want to fight back. Another thing, and I know some companies have kind of we don't hire under 16. It's just too complicated. It's too messy. We don't want to deal with it. Others say it's okay. We'll hire 14 and 15-year-olds. But if you do, you got to follow the regs.
I want to back up. That issue that you're talking about has been a common occurrence lately in a variety of scenarios. And Eric, I don't want to put you on the spot here, but a couple of questions came to mind. The first one is, because it's gray or maybe uncharted territory, number one, do you feel like, you said it, that that's the place where you might want to push back and defend yourself?
Yeah.
My first question is maybe loaded, but do you think that someone who's represented in the process would be less likely to be pushed on that issue So in other words, if you're represented going in by Hinkle Law Firm, as an example, would the DOL be less likely to push that issue on that customer or more likely to push that issue?
You know, I don't think it would affect either way how they're going to push it. I think right now they've been directed, this is how you push it. You are not to include managers, you included the manager. So, you know, they're not going to apply it differently because you have counselor done. I mean, it's kind of a top down, we've been ordered to push on this issue, and that's what they're doing.
Second question is probably difficult for you to answer, but I've taken a call recently from a business in Kansas City. And in this case, the employer wanted to use the tip pool funds at their discretion to reward employees differently. So let's say they come up with a scorecard whereby they're going to get a week's worth of tips, and they're going to credit that back to the employees who worked that week. And they're going to say, employee X worked this many of the hours, so they're awarded by that formula this number of the tips. However, because they show no call one day, they're now excluded from the pool.
Okay.
Likewise, maybe based on performance measures that have been described, I want to scorecard them. So if you are an A+ employee for the week, you get this percentage of what's available. If you're a B+ employee, you get this percentage. And those factors are spelled out. I have taken that question in this whole tip pooling situation to the National Restaurant Association and the Law Council. And they basically said, you need to keep in mind that the tip given by the customer is never property of the business. So it is only property of the employees given by the customer. So if you start dictating where those pools are arranged to, then you've got a problem as an employer. So I know that this is a gray area, this is a new found issue, but it's always been the classic understanding in the business that it is a gratuity or a tip is between the customer and the employee and does not involve the employer.
That's correct. And I think that I'm holding up here, and this is another great example of DOL. They do put out some guidance, some is helpful, some is very confusing, but this is a fact sheet. It's called number 15. It deals with tipped employees under the FLSA, and it's available on their website. But yes, you are correct that, and it references that here, that the tip is solely the property of the employees, unless we're talking about a valid tip pooling arrangement. But you were correct that the FLSA prohibits an arrangement where the employer and the tipped employee, where any part of that received becomes property of the employer, you know. And so, yeah, I mean, you could see the argument. I mean, I took your tip that I'm not supposed to have any claim to, and now I'm kind of using it as a non-discretionary or a discretionary bonus, or, you know, that kind of thing. And so I could see the DOL push back on that.
I've heard from a couple different restaurants where the carryout food tips from that is used towards the beer and party.
Interesting.
Christmas party.
That's a great idea.
I mean, that's a great, it's a great idea, but what, I mean, is that illegal?
I don't think so. I mean, but then you get into what's the carryout charge, and that's the other distinction that I've also been asked to look at recently. You know, tip, and this is traditionally true too. A tip is different from a service charge. You know, are you talking about a delivery fee that is across the board the same, or maybe it's based on the amount of food you buy, or something like that? That is determined by the business. That's a service charge that's going on the receipt. And, you know, you can look, there's tons of cases. Domino's got sued left and right for this because they would have a receipt. This is your total, this is your service charge, and then your tip, you know, line on the customer's receipt when they were doing the delivery. A lot of employees sued Domino's and said, hey, that service charge, that's really a tip. We should be getting that. And the regs talk about the distinction between a service charge like that is determined by the employer. It's not a matter of between the customer and the employee. So the service charge or the delivery fee, that can be property of the employee or of the employer and can be used for whatever purpose. They can keep that, you know, that's not a tip. And so there's a lot of cases where employees try to sue and to get those or those service charges, but that didn't fly.
But like in the case that I just brought up, what about for the employee who is not there at the end of the year? They're not a part of that tip. So I'm just curious about that. Because I thought about doing it.
That's a good question. I have to think about it a little bit more. Yeah. And the other thing I want to point out with this tip change in the law, the other thing was before March of 2018, the DOL didn't really have the ability to go and to seek those tips that had been unlawfully retained or whatever you want to call it. They didn't really have the authority and the enforcement ability to do that. Now Congress has said you have the right, DOL has the power to go and do that. So they're given the enforcement authority to go and recover those tips as well as liquidated damages. So as part of this, you know, how do we avoid potentially bad results? And one of the first things that I kind of was thinking about here is, you know, if you have employee complaints, take them seriously. Don't brush them aside. If there's an employee who comes to you and says, hey, I think we're doing our tip pulling wrong, or I don't think this person should be included, or I should get paid overtime, take those complaints seriously. Try to explain why you're doing what you're doing. They may not believe you, they may not agree with you, but if you are seen as taking them seriously and addressing their issues, they may be less likely to go and make a complaint down the road. Again, you know, become familiar with the rules, and unfortunately the rules change. And like we've talked about today. And so it's good that you guys are coming to these types of seminars. You know, there's others that you can go to, and I know you don't necessarily want to do it while you're going through an audit, but the DOL is available. And sometimes if you have a question, you can reach out to them on a particular issue. Sometimes they may say, well, we don't give legal advice or that kind of thing, but they may point you in the direction, or this is how we enforce that, or this is how we do that, you know. That can be a down the road after you're not involved in an audit. The other thing that I encourage from time to time is to do what I call a self-audit, you know. And I encourage you to use attorneys for this for a couple of reasons, because of the knowing some of the rules and when those rules change. But the other issue is being able to cloak any findings that you have with attorney-client privilege. If we find an issue, we can address it. We can figure out how to fix it, and that doesn't necessarily become, you know, public record. And it doesn't become discoverable in a lawsuit. Say you were sued for an overtime violation, you know, those communications and those audits are going to be protected. And as part of that, if you want to look at your job duties, your job descriptions, you know, are you doing your overtime calculations right? Are you using the right regular rate? You know, do you have the required posters? All of those things, because you know, the old saying, an ounce of prevention is worth a pound of cure. You know, sometimes you can get out ahead of something. It's a lot better than trying to clean up the mess afterwards and get something fixed when the DOL is knocking at your door. As I alluded to, and this is kind of a don't forget, what we're talking about today is just the U.S. Department of Labor, the federal government wage and hour division. So they are not responsible for enforcing state laws, whether it's Nebraska, whether it's the Kansas Wage Payment Act. You're going to have other state law issues that the DOL doesn't care about, enforcing those laws. Kansas Wage Payment Act, many of you probably have had to deal with that. Sometimes deals with timing of payments, whether, a person is fired midweek. Well, when do I have to pay that person, their final paycheck? It also deals with deductions from pay. When are you authorized to make certain deductions as far as things like uniforms? When are you authorized to do deductions for cash advances or loans, those types of things? And the other important thing is wage and hour doesn't enforce other federal employment laws. There's other divisions within the Department of Labor, such as OSHA, going to do workplace safety. And then there's the EEOC that's going to oversee, Title VII, your disability issues with the ADA or age discrimination issues with the ADEA. And then there's the NLRB, which enforces the National Labor Relations Act, which, covers such things as typically when you think of that, you think of, okay, unions, that's what you see. Okay, well, we're not a union, we don't have unions, so we shouldn't have to worry about that. But the NLRB, they enforce things such as you can't have confidentiality, wage confidentiality rules. You can't have policies that say you can't talk to your employee about what they make. You can't have that. You can't have any type of policy or procedure that has the effect of chilling employees' ability to talk about the conditions of their employment. And so those are out there, and just as a reminder that you've got a lot to worry about sometimes, unfortunately. Like Adam alluded to at the beginning, there's a lot going on, and this. When we talk about the wage and hour division, they're mainly going to be talking about FLSA, FMLA, but there's a whole lot more out there. So, fortunately, it went a little bit longer, but you've kind of had some questions interspersed. So, yes, ma'am.
If you find that you owe back wages and you are on a full basis of accounting, do those count as current year wages, or do you have to go back and restate in the prior year?
Yeah, unfortunately, that's an
I
accounting.
overthink things a little bit.
No, that's a good question. Unfortunately, it might be more of an accounting question than I'm not sure. If you're doing that on a full basis, I'm not sure how that would.
I got kind of a general, question that I think will turn into a statement. So when I get these calls, and I get them a lot, especially lately, which kind of alludes to what you said, that they're targeting the industry. And I think that's for a lot of reasons, but probably because there's a lot of opportunity for breakdown and failure. And so they like to find things. They don't want to go inspect someone, audit someone, and not find anything. They feel like they probably need to find value in their service. But I had it asked to me, and I thought I was right the way I answered, but I want to make sure, here. Do you feel that a represented client is, like some people will say, well, I really don't have anything to fear. I'm not intentionally doing anything wrong. I don't want to bring an attorney in because then it'll make it look like I'm hiding something. I don't think that's generally correct. And in fact, you talked about all these gray areas throughout the presentation. And maybe I'm wrong in saying this, but it seems to me that because of all these gray areas, maybe an inspector would be less likely to dig into a gray area if you're represented versus not represented. So kind of where's the nexus on all that? Like the value of having an attorney versus not having an attorney. And
Sure.
maybe that's loaded up because
I think
you work here.
all
So,
get attorneys.
yeah.
I agree with you. I mean, I don't I think there is value in having an attorney throughout these process. I do think, though, there's also some value in having it before the DOL comes. If you've got a question, pick up the phone, spend a little bit of money instead of having to spend a lot on the back end, you know? And so I know that people you don't like to hire attorneys, you don't like to pay attorneys, but sometimes if we can try to fix something before it's broken, so to speak, or before the federal government finds out, it might be very worthwhile. I do think that there's some value in being represented in some of these situations, because I think we'll try to steer you in what information to provide, how to answer questions, so that it necessarily doesn't open up a Pandora's box. Sometimes that can't be avoided, unfortunately, you know. But you do see, I've got nothing to hide, and you shouldn't have anything to hide. You should be cooperative, but sometimes I think that, you know, I'm helping a client right now in the Kansas City market, not a restaurant, but, you know, we met with the investigator and did the opening conference. And we were able to just go through point by point, here's how we do it, here's, you know, and he took our word for it instead of saying, oh, well, let me see that. So when we got down to the end, he was just like, oh, okay, well, I don't need to see the record on this, or I'm fine with your explanation on that. So I think that sometimes having an attorney can help, obviously, but what we want to do is to help you before the DOL comes on. But, you know, if it does, and there are these gray areas, I think it's helpful to be able to push back. You say, hey, Mr. Investigator, there's this case law that says this, you know, and, you know, before 2018, the law was this, and you know, this court case ruled this way, so you're interpreting the law wrong, or something like that. That's where I think that you can, an attorney can add some value there. So, any other questions? Yes, ma'am.
I have one person that she's a hostess and she only works on weekends and she doesn't want to clock in and out. Everybody else does. She told us, you just pay me 14 hours a week, and this is, you know, we agreed on her hourly wage, and she does not want to clock in and out. And she says, you know, if she needs to leave and do something, we're all good. So are we going to get in trouble if this one person does that?
Possibly.
Everybody else is clocking in and out.
Yeah, I mean, there's some regulations that talk about that if they work the same. If they work the same shift, the same hours, but then there's.
She's the one who came to us.
Yeah.
Said, I don't want to clock in and out. You pay me this many hours.
There's a regulation that talks about that, but there's some additional, I don't remember it off the top of my head, that if then she works more than, if she works 15, you have to have a review or timesheet, I think, if I'm remembering correctly, and note any changes. So my advice is make her clock in, because the issue is if you come back, and one of the investigators, her name is Susan Lane, with the DOL here, she likes to say, and I think she's right in most instances, records are your best friend. So if you've got a time record that she clocked in and she worked, 15 hours, then you pay her for those 15 hours. What you're gonna, and if she works less than that because she leaves, you don't want to be paying her for 14 hours if she's not working that entire amount too. I think what you're going to run into trouble, potentially, is what if she becomes disgruntled and 2 years from now she says, hey, I've been working 30 hours and I'm going to sue you, and you don't have any records to kind of back up, you know? And so I do think you want to do that. You want to make her clock in. And kind of, I'm curious why she doesn't want to, why she suggests that.
She's over 70 years old. She doesn't want to.
Understood. But I think best practice would be to make her clock in and pay her what she works. So.
I have a question for you.
Yeah.
Tips. Do a tax credit where employees supposed to report their tips each week, get paid weekly. Say that the employee does not fully report their tips, especially like credit card tips, where you easily see what it's supposed to be. Say that their credit card tips are showing $500, but they're $400 for the week. What can you do as far as, can you basically give them full warning saying, okay, you gotta report at least what the credit card tips is doing, so therefore, because we want to be sure it's getting proper report basically, because you can really see it right there. But say that they do just go ahead and report exactly credit card tips. No, they got some cash as well. Can you possibly, you know, for more warning as well? At the same time, say, okay, we know you got some cash tips too.
Yeah.
Why haven't you reported?
Yeah,
Is there unreported cash?
I'm not sure, and that's a question I would want to look into more. I mean, I certainly think you should have a policy that says, yeah, you've got to report to us. I mean, because as you know, I mean, if you're not making up that $725, the employer's going to have to pay it.
Right.
And so you don't want an employee double dipping, you know, essentially.
Right.
Saying, hey, I pocketed all this cash, but you didn't pay me the federal minimum wage, so you got to kick in some more.
Right.
I'm assuming that there's something that you can do and having a policy and disciplining that employee, but I don't know off the top of my head, but it would make sense.
Yeah, just do a formal warning or some sort of basically.
Yeah.
That's kind of.
Yeah.
So, I'm curious, the gentleman in the back, did you get your question answered? You about assistant managers, supervisors.
You know, to a certain extent, and in our specific situation, I'm gonna have to look into it and see what applies to us. Our service model, our supervisor structure is a little atypical from your usual table service type restaurant. You know, it's not an issue of wages. It's like, I just wanna make sure everyone has a perfect job. I don't have to pay salaries, you know.
Yeah, and I think you're right. I mean, it's, a lot of times it is fact specific, and because you call somebody a supervisor, what does that mean? You call somebody a manager or shift leader, what I mean, they're gonna go and look at those duties and make fact specific inquiries into it. So that's what.
And from my experience from that getting audited, whatever you title your managers, shift leaders, be aware of how you're titling them. Because,
Yeah, don't make it assistant manager if they get,
yeah,
we took ours down to lead server.
shift leader, figure out a different title, because, one person that they're going after that works for me is the manager. And according to the definition that I gave him, and that's from the DLL, there are certain things she does and certain things she doesn't do, most of the stuff. But she's like every other employee. She works at every station. She just does whatever. And that's kind of how it is. But because of the fact that I labeled her as the manager, the tips that she got from tip pulling, I have to pull out of my pocket to pay the people who work during those time periods. So just figure out what titles you have for your employees. If they're salary, you're kind of stuck.
You really drilled our general manager to make sure that she was doing the operations, like you call for repairs through your vendors. Do you hire, do you fire?
Yeah.
You know, I mean, it was truly those questions where by the luck of whatever, our kitchen manager, our head of the kitchen has been on hourly. He does have the ability to hire and fire, but he truly is more of a workforce. Like,
You pay overtime then?
oh, yes.
Okay.
And that was one thing from the beginning, I think, is that when he saw that we only have one salary person on the staff, and that was the general manager, and his one-on-one with her, he determined, oh yeah, you do manage. That is all you do is manage. She's not serving, she's not, doing anything. But for who we call kitchen manager, he was like, oh, but he's hourly. Well, yeah, and you could see this gentleman gets a good overtime wage.
Right.
So.
Yeah, I mean, that's twofold. I mean, they're trying to look at your general manager, however you phrase it, to make sure that they are doing the because you're likely not paying them overtime, so he wants to make sure you're classifying them correctly. Because I do see that there are some establishments that will classify people as assistant managers that don't really have a distinction between them and another hourly employee. And so we're trying to pay them on a salary basis, we're trying to pay them for they're working 60, 70 hours a week. You can run into some big problems there, you know.
It's just really better to pay the overtime. And I mean, I know for us, we were trying to reward our staff by giving them that title, thinking that was an award for, they're moving up the ladder.
Right.
No, it would hurt them more. And Adam, into your question, when you were saying, I was on the fence. Do I hire an attorney or do I not hire an attorney? And it weighed very heavily. I would have absolutely had counsel if I was in a situation like Chipotle, where you're taking the tip, like at the front, it's not really the server, it's not really the true, I feel like my establishment is the old fashioned server situation. I mean, anybody who's in on the tip pool, which is 3% of my server sales, they donate to the tip pool. That tip pool is then dispersed by the support folks, those cashiers and customers. No, dishwashers have never been in any of that. And when he was interviewing me over the phone before I knew you weren't supposed to get real chatty, that would have been real handy the day before I had that conversation. But I became real chatty with Guadalupe on that initial. And I was kind of asking him, confirming, well, my kitchen manager is hourly. Oh, and gets overtime? Oh, absolutely. And it was kind of like, I ruined that bit of fun for him. Everything. And so when it came down to it, I felt pretty confident. Like I said, the one only glitch was it affected a couple of employees who had some overtime that it will be less than a $50 difference. So I chose not to go with counsel, but I absolutely would have if I felt like there was a lot of gray areas that were affecting me. And then I could be completely snowed over because I haven't had my findings.
And that's the problem. Sorry, you don't know going in.
You don't know until.
You don't know going in, you're not the only one, Zuri, so.
Yeah.
And systematically, it seems like, and the question came up, why am I being targeted or why am I going through this audit? And it seems to me that complaint inspection is an easy reason why you might, but it also, they seem to systematically go after college towns. And if you've looked in the paper over the years, you'll see a string of audits for Lawrence and Manhattan, and to a lesser extent, the smaller college towns. And I think the reason is they feel like there's a lot of labor to exploit in those communities, because these are kids that are trying to get every hour they can. They may work at multiple restaurants within the same ownership group, within the 75 miles like you just talked about, and things like that. And there's been some crazy things that have happened recently that I wish these owners had been represented. There's a brewery, and I won't say where, actually 2 breweries that I know that went through a big audit. And in both cases, they were nailed on tip pooling. Even though they didn't direct the pool, the servers had decided they were going to tip, for instance, dishwashers who are not facing the front. And the reason is because they thought these people work really hard and I want to help them. And so the employer is not getting involved at all, but the Department of Labor auditor decided that they were creating a culture where a server couldn't say no to that pool, and they were allowing it to happen. And it created a pattern over time that is the policy of the business. And so, and he had been audited 6 years prior and didn't get stung on that issue, and then 6 years later got nailed on that issue. And I'm not talking about a small amount of money. I'm talking about over $100,000. And so that's a gray area to me, because And if he had been represented, and, you know, by the time the cat's out of the bag, it's almost too late. And he was so confident going in, he didn't think he needed it. And it's like, you don't know what they're gonna dig up. And so, for pre-work, you talked about it, and I wrote down best practices. We need to come up with some worksheets for self-audits and things like that. And the association needs to be putting out information all the time, because times do change and laws change. But this is a big deal. This is a big problem in the industry. We are under attack every day from countless entities and governmental agencies. And I don't know how you do it, guys. You run maybe the most difficult business on the planet to make money. And God bless you for doing it, because you're putting people to work and you're giving people livelihood and you're pursuing your dreams and passions. But it's so very difficult to do what you do. And that's all I really have to say. Unless there's any more questions, we probably need to wrap.
I do have one more question.
Yep.
We've been talking about tip pooling specifically. Now, we have a catering operation that, while falls under the umbrella of business, absolutely, it's not, it's not a part of the tip pool. So, for example, I'm our general manager, I go work with them. Is it illegal for me to claim, and the client decides to include gratuity, is it illegal for me to claim these gratuity?
That's one of those areas that it's unclear, because is that, a manager isn't supposed to be getting a tip, but that's your tip. You're the employee getting the tip, So
That's the only employee working at a event as well.
Right. So it's.
You find out, because I have an event. Well, her title is event manager, and she does all the caterings, and she absolutely gets, whether you call it a delivery fee, whether you call it this or
Yeah,
that,
you call it.
it's what she earns for.
Yeah, if it's more of a service charge where you're saying, per event, it's 20%.
Yeah,
that's
it is
more-
more of a service
And
charge
that's probably gonna fall more in the okay to give us that,
to give it to her. Okay.
because that's not a tip.
It's always negotiated, and yes, it is.
But then you get into what if they just wanna throw in some more, you did a really good job,
Well, then hopefully it's cash, though.
Side note issue that you're talking about adding it in, just remember that if you add it in, you have to collect tax.
Oh, yes.
A lot of people forget that part. If it's a service charge, it's taxable. If it's gratuity, it's not. So, keep in mind. There are all kinds of fun things. So,
Right.
All right, well, thank you all. If you have questions, something you wanna talk about, come on up, we can talk more. I'll be here for a while, so.
Probably.
It is, it's one of those where.
Yeah.
We had these how do I make the?
Well,
So, I guess there's how eventually they would have overhead.
Thank you. Don't do any more. It's bad for me, because I can't try. So I did this job, and
Hey, thank you.
So, Okay, so
How do I
I
handle
heard
it?
it. I heard it.
But there's so many others, why do you think we won't do it before?
So we're representing, so just like.
I don't know.
You have clarification for the
I'm on and we have.
Yes, sir.
You're reviewing.
I like
For years, for the hours, so I have a certain.
they are clearly, I have this one. Says how much they're right.
No.
And that's because they're under the every. I can't make claims. And she actually, my only problem, my strategy, I use your checking. All right.
See ya.
Yeah.
Drive safe, guys.
And it's just.
Yeah.
So her question, I don't know. How do you force them?
We do not use utilities. We have a sheet of paper that we're supposed to fill out. I try to, and their credit card tips. I can clearly, I run a report on the credit card tips and they're clearly there. And, I've made a chart where I've done some, so that I can fix anything. And I, and if they don't fill one out, then I'm just going to change sheets down. But I have people, I've had a person one day, if I can't make that. And then ours
No, I don't need.
I know it's not right, but why can I, you can't say, how you can't just say at the end of the day, okay, let's take all that trash down your paper and have it down. Can you do that? Because I just, how can I count your cash, how can I prove
I
that
think,
she's
well,
hiding?
the easy way would be what I talked about.
And he really drilled my general manager question. He said, I want to drill somebody who works in dishwasher. And I'll tell you somebody who uses
My service
servers.
was.
I didn't know anything about this kind of stuff, which is where I have.
So just say-
Let's get it.
Performance model for termination.
But I'm gonna have to give a formal notice to everybody saying there's going to be weekly audit. And if you don't, put that
We have a lot of kids, we have a lot of franchise students.
Yeah,
And then he brought the
I need to see at least 1%.
employees.
Whatever.
So,
you do.
we take it a little later.
Even at 20, even at 20.
He wasn't trying.
Well, the thing you gotta think about.
Being
is-
agreeable.
You think it's 20 is the
I got
standard.
scared, I mean, right?
I had these people, it was very clear, it was, that 40% have their credit card. And it went even out. So, that's minimum.
I think that in my world, I integration perspective. We probably would be reviewing an employee after 20. That doesn't transcribe.
She wasn't one of the aircraft before that.
I think you're right.
Here,
Thank
very
you.
nice to meet you.
I know, very nice to meet you. Thank you for your time. Yeah.
What do I need to do to help you?
Well,
He
I know. We want you to
I
have
know.
money.
He got so much
And it's
money.
right when you
He
get
said, it's right. And I'm like, wow.
So we need to look at the team.
I'm still not
You
sure
have
I
any
understand
You have
how you
GM,
get to it.
somebody
Yeah,
like
yeah.
that.
I know you.
Thank you for
I
having
don't know if your teacher is incentivized.
You have it all together, so it takes like 4 hours in one way, and it's like the hours. And all together, that's how it comes like that. By the time the hours, that's the rate you take times 1. Why? Because, we're the majority of his role is a busser. And then one day a week on Sundays, manages Sunday brunch. He's the runner, he's the one who's in charge of keeping all this stocked, so it's a higher wage. And on this
They
particular,
will give you these opinion letters, which are the, if you go to the URL, there's a.
but she had to have consequences for ladies. So he was having to come in an hour before his shift to do deep cleaning. That finished the overtime. And it's been like, I was like, almost like violated because I wasn't sure, you know, I ripped off to like,
This.
just like, well, we're not in now, I know. But it's still, I'm looking to tell.
But the one.
I'm not an accounting person, so.
If someone else is giving you.
But that's and you always account. Because I was there,
I'm not doing my part. So it's a organizational purpose.
like, those cash sales don't count.
If you tip that away, you cannot tip anybody.
So-
So
I will never be rich,
in order
but
to.
I will be on, like, my numbers are true.
You have to face the guests.
My
So
cousin who owns
if you're
a deal in Georgia,
you don't come out.
I'm like, we're visiting this summer.
If you're a dishwasher, you don't come out. You don't ever interact with
She goes,
guests.
oh, yeah.
Only
For the cat, the holiday pie pickup, cash line goes here.
That's really.
She's like, you don't do that. I'm like, oh, for the love
See,
of God,
we do have a
no,
couple of
I don't know enough to be able
We
to know
have
how to.
more than one dishwasher.
So, I think the way you kind of tell us.
So they would have to switch
Cash
out
registers for cash.
to be able to tip.
It's really.
Because we do tip. We do tip, we tip on weekends. That's the only time. It's hard.
Oh, yeah.
Hey, we'll see you, Tim Marie.
I hope that Lisa, we can find it a little later in the time. I did, and I was kind of smart aleck, so don't let her take me as I was waiting. When I was in California, they were in night, like, oh, we can have so much friends. In the restaurant business, Sunday, 9 o'clock.
Yeah.
I want to wear at 9 o'clock.
I got you. If you're presenting issues.
Yeah, I know.
At least it's.
But like you said, if you don't, how do you know that when you need to make up the tip, I mean, make up the, that you're not reporting, that's correct? you know, or under-reported.
They are under report, right?
Yeah.
But what can I can't get a thing done.
Just wrestle with it. We have two single.
And then they just like, I get a look.
Especially, it's easy to see.
Yeah.
Yeah.